Hello, everyone, and welcome to another edition of our weekly webinar series brought to you by ImmigrationQuestion.com, your go to platform for real time immigration insight, legal information, and meaningful conversations. My name is Anusia Mukherjee, and I'm glad to be your host today. For many people, family is the reason they begin their immigration journey. Whether you're trying to reunite with a spouse, sponsor children, or help parents gain permanent residency, family and marriage based petitions remain one of the most common ways to obtain a green card in the US. But while it's a well traveled path, it's not always a smooth one. That's why today's topic, Pathways to Residency Navigating Family and Marriage Based Immigration, is one we're especially excited to explore. Joining us today is an experienced and bilingual immigration attorney licensed in both Florida and Colombia. She's earned her US law degree from St. Thomas University in Miami and has been a Florida board member bar member since 2006. As a co-founder of Gomez and Zetagu, she focuses her practice on deportation defense, family petitions, waivers, and appeals. Fluent in both English and Spanish, she successfully has helped hundreds of families through difficult immigration processes. Welcome with me, attorney Adriana Gomez. You're welcome, attorney Gomez, and we're glad to have you here.
Thank you for having me.
Thank you. To our audience watching live, grab your notepad and get your questions ready. This promises to be an interesting session. So, my first question would be, can you give us a quick overview of how the US immigration system works when it comes to sponsoring family members or spouses?
Right. There's two ways to do it. Either your family or your relative is here in the United States. We call that adjustment of status. You first like file in conjunction an I-130 and I-485 application with USCIS. The most important thing to know is that if we divide it in two different categories: immediate relatives, which is like spouses, children younger than 21 and unmarried, and parents. The parents,
Mhm.
the child, which is the United States citizen, has to be older than 21. So those immediate relatives are the relative of United States citizen. Those can adjust here in the United States. The only requirements that they had to enter the United States legally, either with a visa, with a parole, or like CBP parole, CBP1 parole, and then you can file the adjustment of status. If that's not the case, then you have to do the I-130 first, and then you can file a consular process once your I-130 is approved and there's a visa available. Because I told you there's immediate relatives, but there's other categories with family preference. Family
Mhm.
presence are like, for example, children of United States citizen parents that are older than 21 or they're married. You can also file a petition for your brother and sister of United States citizen, or for example, if you're a legal permanent resident, you can still bring your wife. That is a family presence. It means that you have to wait a little bit to be able to that person to become a resident, because you have to wait for a visa availability, and it could take between 2 years to like 5, 6, or 10 or 15, depending on which category.
Thank you. Now, let's walk through some of the most important paperwork. What are the I-130 and the I-485 forms, and what are some common mistakes to avoid when completing them?
Right. So the I-130 is the petition that files the United States citizen or the resident. So it's on their name, which is either the spouse or parent, right, or child. So the I-130 is the first part of the process. You need that in order to become a resident. If you don't have an I-130, then that means that you don't have the family petition that you need. The common mistakes on the I-130 is that you have to understand where is it that your relative is going to do the green card. Either they're going to do it as adjustment of status here or outside of the United States, and you have to check that box, right? To
Mhm.
make sure that you send it to the correct place. So, for example, let's say I'm filing for my brother, which is in Colombia, right?
Mhm.
If when I filed the I-130, I don't say I want the case to be transferred to the National Visa Center because he's going to file a consular process in Colombia, then the I-130 can be approved, but the case will never be sent there. So now I have to file a new
Okay.
petition to
Mm-hmm.
ask USCIS to transfer the case to National Visa Center, and that could take years for them to do it.
Mm-hmm.
So that is one of the common mistakes that I see. The I-485 is the actual application for the green card. So let's say that the I-130 is like my foundation. Um,
Mm-hmm.
I would say that the one I-130 is the one that, like me as a United States citizen, will ask, okay, because of my family relationship to my father or my wife, I
Mm-hmm.
want them to be able to become a resident. Then the I-485 is the actual immigrant saying, okay, based on that family relationship, please grant me my green card. And that I-485 is based on the immigrant. So all the
Mm-hmm.
information, everything that you will see there is on the immigrant. And the thing is that that application is like 25 pages. Okay, it's a long application. It has a lot of questions. So you have to make sure you answer all those questions correctly and truthfully, because maybe you don't understand the question, or you don't understand what they're saying, or why this is coming from, and you say yes when you were supposed to say no. Then the officer will say, well, you lie your application, because you sign at the end saying you sworn that all the information is correct. So that's why
Mm-hmm.
it's very important to make sure. And that's one of the common mistakes, that people say something that they didn't understand, or it was because so long they didn't file it correctly. And usually then immigration will send you a request for evidence saying that
Mm.
they need more evidence, and sometimes you don't have it.
Exactly. Exactly. So once those forms are filled, how many people start thinking about what comes next? What should applicants expect during their USCIS interview? And how can they be best prepared for it?
Right. So the I-485 interview with USCIS, you is those only happens when you are doing an adjustment of status here, right? So that means that you file your application, you got your work permit most likely, and now you have to be an interview with the officer. Now it would depend what family relative is the one that is a petition for you, because that will tell you what documents you need for your interview.
Mm-hmm.
The ones that you always will need is the passport of the immigrant with her birth certificate, I-94, which is evidence that they entered the United States illegally, which is one of the most important requirements. Um, Also, you need to prove that your family the petitioner, which is the person that is filing for you, either the citizen or the resident, has enough income to support you, which is we call the affidavit of support. So you will need evidence to show that. Yeah, bank statements, or most importantly, income tax return, right? Maybe pay
Mm-hmm.
stubs from like the employer to say, or a
Mm-hmm.
letter from the employer. Also,
Mm-hmm.
if it's a marriage base, you 100% need evidence to show that it's a bona fide marriage, which means that you
Mm-hmm.
live together. So, for example, you need bank statements. You need, for example, lease agreements, car insurance. If you file your taxes together, pictures together, trips that you have made together, right? So you have to. And I always advise my client: do not send just the last receipt or last bill, just one bill and nothing else. No, no, no. As many as you can. The farther
Mm-hmm.
back that you can send, the better. And you will bring all those evidence with you at the interview. Also, if you don't speak English, you need an interpreter. Okay? Very important. The interpreter is the most important thing, because if you don't speak the language, then the officer can they will say it as you were never there. And it's your responsibility to bring the interpreter. And additionally, well, you can use a lot of, like, there's a lot of help in social media, in YouTube, or like samples of interviews, so you can watch them and you can review. Make sure you review your application to see if there's a mistake you need to correct, there's something that you said, because this is the time to correct it. Let's
Mm-hmm.
say I made a mistake in my application. Okay, now I can correct it and say to the officer, listen, officer, I put this here, but this is incorrect. Now I
Mm-hmm.
can clarify. I'm no longer lying. I'm no longer saying that just it was just a like it was just a typo, right? But I can
Mm-hmm.
correct it. I said to the officer, listen, I checked my application and I have a few mistakes. I wanted to correct it. And then that's the
Mhm.
perfect time to do that. So you can help. You can that way you cannot. They cannot tell you, okay, you lied because you're correcting it.
Makes sense. Makes sense. Thank you for that. Let's pivot a bit to issues that can cause delays. What are some of the common pitfalls that can lead to delays or denials? And how should someone respond if they receive a request for evidence or an RFE?
Right. So the most common one that I have seen is they don't send them the medical exam in adjustment of status. And the thing is that before the practice was that nobody sent their medical exam with the application,
Mhm.
right? Because it was immigration take too long, the exam was only valid for like certain amount of time. So you didn't want it to pay double. So you're like, no, I will bring it to the interview or send it when they requested. But now if you don't send it with the application, it can cause delays. It can cause like the case be denied. Other thing
Mhm.
is like the affidavit of support. They all, if you don't send your document showing that the sponsor, which is either the petitioner or somebody else, if the petitioner doesn't comply, you don't show that that person has enough income to support all his household and the immigrant, then they will send you a request for evidence 100%. You have to send, for example, the birth certificate of the immigrant, the marriage certificate, divorces decrease from previous marriage if it's a marriage application.
Mhm.
So there's a lot of, and then you have to make sure that you respond to their RFE in a timely manner. So if they say the documents have to be submitted by May 30th, May 30th is the last day you have submitted. So make sure that at least it gets there May 30th, hopefully, at least the 29th. So if there's a delay in your process, then you can. And if you have an USCIS account, the best way to do it will be to upload it into the system in
Mhm.
US account, because that way you sure that they receive it and then receive it in a timely manner. And also, I have a lot of clients that unfortunately they open the USCIS account and then they think that they're going to receive the documents by mail. They don't.
Mhm.
It's email from now on. And the email is just going to say, we take action on your case. But that's it. That's the
Mhm.
only thing that you have to go into your account and look what is it that they send me. So you go into different tabs, not only the first one, you go into the documents, go into the notices. So they see what I sent it, because I just had yesterday a client that he missed his interview appointment because in the thing it says, we schedule an interview appointment, you're going to receive it by mail. And he thought
Mhm.
mail like in the postal services. No, no, no. It was email in his account. So
Oh,
they missed the interview, and now the case is denied.
okay. That's understandable. To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a two-in-one platform built with lead and case management to help simplify the immigration process. You can ask your immigration questions for free in any language and get connected with a verified attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. Now, Attorney Gomez, as a platform that connects documented and undocumented immigrants with trusted attorneys like yourself, what are your thoughts on how Immigration Questions supports the immigrant community today?
It's very important, because you need someone to be able to rely on give you like correct answers. We as attorneys, we don't have all the answers, but at least we have experience and we have seen the issues, we have like work to be able to be a professional and answer the questions. So the more you know about your case, about how what's going on, it will help you not to be in a panic and to understand what is your case and what is it that you need to do to move forward.
Thank you for that. Before we get into the live Q&A session, let's get into a question we get a lot. What advice do you have for individuals dealing with issues like inadmissibility or needing a waiver during their adjustment of status?
Right. To honestly, I know it sounds kind of like weird, but it's seek the consultation with an attorney to review your case, because maybe you don't need a waiver, but maybe you do need a waiver, and you have to submit that waiver in conjunction with application of 5485, because if not, immigration could deny your case because that's the new rule. You're supposed to submit it all together for the officer to review. Also, make sure if you're inadmissible, that means that there's an issue with your case, either because you have been arrested or convicted in the past, either because you lied to immigration, either because you turn in false documents. So there's a lot of things that could happen, right? You enter the United States illegally, you have an order of deportation. So those every waiver needs a qualifying relative. That means that there's a person that will suffer extreme hardship if your case is denied. And those qualifying relatives are varied depending of what is your inadmissibility. So for example, if I have fraud, right, or if I have illegal physical presence, my qualifying relatives are my parents or my spouse, United States citizen or legal permanent resident. But for example, if I have crime, then my son will be a qualifying relative, which in the fraud and illegal physical presence couldn't be. So it's
Mhm.
different. And you need to make sure you know that, because if not, then you file an application that you know is going to be denied because you don't have the qualifying relative. And now in this age, immigration, as soon as they will send your deny your I-485, they can send you to removal proceedings because now they know you're here and you have no status. So they will send you to removal proceedings. So you have to make sure that you're doing things correctly before you start your application.
Thank you for that. To our audience, the floor is now open. Drop your questions in the chat and we'll answer as many as possible. If you'd like to call us live and ask directly, dial 516-703-3483. So our first question is, my husband filed for me, but he makes only 80% of required income. Can his mom be a joint sponsor? She's not a citizen, only a green card holder.
Yes, she can be the sponsor, and it could be depending. If your mother-in-law lives with you, you can add your husband's income with your mother-in-law's income, and then that will you can meet the 125% of poverty line that you need to be able to become a resident. But if she doesn't live with you, then she needs to comply with her income with the 125%. But yes, it doesn't have to be a citizen. And actually, this joint sponsor doesn't have to be a relative. Okay, it can be a
Mhm.
friend, my employer. It can be like a family friend. It doesn't matter, or even like a pastor.
Okay.
As long as they're willing to sign the affidavit of support, then that's good.
Mhm. All right. Thank you. Our next question is, I have two kids from a previous marriage. When we apply for our I-130 for spouse, can the children come together under derivative? Sorry, excuse
Right.
me.
So the thing is that you have to make sure two things. If I have
Mhm.
kids from a previous marriage, and now I'm applying with like my new husband, my husband can petition my kids as long as the marriage occurred before the kids were turned 18. That means that they're going to consider the stepfather. Now, in the ones if they can become together with one application as a derivative, it depends who my petitioner is. If my spouse, which is going to be the petitioner, is a U.S. citizen, no. Each child has to have an I-130 separate, and each one has to have like an I-130, I-485. Each one has a different package. But if my petitioner is a legal permanent resident, then yes, the spouse and the children can come with just one I-130, and that will be able to uh, file the application. But it will depend of who my petitioner is.
Okay. Thank you. Next is, what if my spouse passed away before I get my green card? Can I still adjust status or need a petition by someone else?
You can, if your husband was a United States citizen, you had already filed an application for the I-130. Okay, you're here in the United States, and then you file your application for adjustment has to be filed before like 2 years has passed since he died. Let's say we had already filed my application, everything was just pending, and he passed away. I still can become a resident, okay, even though my husband passed away, if I'm in the United States, and my husband was a US citizen, right? If we haven't filed the application yet, but I'm still in the US, I can file the application instead of the I-130. Now my application was going to be an I-360, as a widow,
Mhm.
as long as I file my application before 2 years after he dies.
Okay, thank you. My wife and I live apart because of my job. Do we still prove bona fide marriage? What evidence is strong?
Yes, and those cases are a little hard to prove, is because immigration will like think that your marriage is not a bona fide marriage. So you need to have as much evidence as you can. Evidence that is strong, income tax returns together, bank statements together. For example, if you have like trips, right? Because you have to go for and back to visit your wife, or your wife visits you, then like airplane tickets, right? Things like that to show, and pictures together. Maybe you do a trip together. Those things are strong. So evidence that is stronger is bank statements and income tax return, and I would say trips to see each other.
Thank you. For a spouse visa interview, I speak little English. Will they allow interpreter that is a family member?
No, unfortunately, no. You have to bring an interpreter that is not a family member, and I recommend it because not only is very personal, is that they ask a lot of questions, and you want to make sure that the interpreter is on point, that they're paying attention to what I have seen. I have gone to the interviews when there's a family friend, no family member, because you cannot have a family member as an interpreter, but a family friend, and it's not good. Like they don't pay
Mhm.
attention, they forget that you have to actually um, think something else. So no. And then there's a lot of interpreters, just pay them, and it's not that expensive. So my advice, use a certified interpreter.
Okay. So our final question is, my fiance filed a K-1 but got denied because of a minor criminal record. Is there a waiver or do I need to start over?
In those cases, I honestly believe that instead of starting over, the best way to do it would be to go get married and file an I-130 and do a consular process. Because if it's a minor criminal record, most likely the green card is going to be approved. And if they need a waiver, then you can do it that way instead of the K1, which is going to be so hard to be approved. So my advice would be get married. So you have to go to your fiance, get married, and then when you come back, then you can do the I-130 and do the process as a green card holder for consular process. So the I-130 first, once the I-130 is approved, they'll send the case to National Visa Center, and then the National Visa Center will schedule an interview in the embassy. And the embassy will let you know if that is like, if it's admissible, there's an inadmissibility or not. If it's a minor criminal record, it shouldn't be.
Okay. Thank you. That was our last question. And that was an excellent way to end our session. Thank you so much for joining us. And a special thank you to our special guest, Attorney Adriana Gomez, for your practical and strategic insight. We hope this webinar helped answer your questions. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our website to learn more. Don't forget you can rewatch this session or listen to previous episodes on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again for a special session on Wednesday regarding another trending immigration topic. Once again, thank you, Attorney Gomez. We look forward to having you back soon. Thank you.
Yes, thank you so much. Have a great day and happy
You
and
too.
Memorial Day weekend.